We have one case on the hearing docket tonight. It's case number APPL 112-2025, filed by Sidra Ihaz, if I'm pronouncing that correct, and Kuram Riaz. Owners are requesting a variance and appeal to allow a residential apartment or housing unit at first floor ground level within an existing structure located at 117 Willow Street with within the B1 shopping district. I'm getting feedback there. So this is located within the B1 shopping district. It's associated with the property address of 142 Market Street. It's located in the rear of the building, which is assigned the address of 117 Willow Street. So in your packages that we distributed both by email and by handout, I included a staff report, which I will highlight. In addition, I have some other exhibits as part of the staff report. The owners of the building are seeking then a variance and appeal to allow the conversion of the first floor of a one-story building located at 117 Willow Street from business to residential use. The building itself is connected to a larger building with frontage to Market Street, and that is identified as 142 Market Street. So in your package, we've included an Exhibit 1, which is the State Department of Taxation information sheet. Exhibit 2, a letter of explanation provided by the owners. Figure 1 reflects a drawing of the interior submitted by the owners. Figure 2 represents a Google Earth aerial image, I believe dated 2023, possibly earlier. Figure 3 represents a street view from Willow Street. The drawing that the owners have submitted shows a footprint of approximately 660 square feet in association with the building interior and room layout with dimensions of approximately 30 by 23 or 22.8. It appears to contain 2 bedrooms, although upon further inspection, it had just 1 bedroom with 1 other room as a storage room, a bathroom, and a combined kitchen and dining room area. The owners installed a kitchen sink stove to accommodate the residential use. Additional pictures of the interior were requested. I did take photos of the bedroom last Friday. 5, I guess, or whatever it's assigned appropriately.
Just so the record's clear, what's the exhibit that's being entered at the moment? The staff report, or?
It's part of the staff report. It's interior photos of 117 Willow Street. It includes 3 different photos.
Just so the record is clear, I assume, Mr. Brandy, that you're going to submit your entire staff report as an exhibit. Okay. And for presentation purposes, the exhibits that are attached to your staff report, do you intend to submit them as separate exhibits, or is the staff report one exhibit?
It's one exhibit.
Okay, so we'll just receive that as Exhibit 1, the staff report. Okay, thank you.
So the building's residential use as a 1-unit apartment was discovered in October of 2024 based on reports from adjacent property owners. Staff informed the owners they had to cease operation as a residential use, but had the right to appeal and file for a variance. Their other option would be to apply for a zoning map amendment. Due to delays in meeting advertising requirements and lack of board appointments, a public hearing was not scheduled earlier. In terms of existing conditions and land use and zoning, the building associated with 117 Willow Street was formerly a beauty shop and most recently was a gift shop in 2023. It consists of a one-story brick structure believed to have been constructed in 1926. It has two entrance doors to Willow Street. The property has no off-street parking. A portion of the building associated with Willow Street is not believed to have access to the remaining two-story building connecting and fronting Market Street. It's one building, but it doesn't have combined access. The latter building contains a vacant retail space and an occupied upstairs apartment, which is a two-story building. Property is zoned B1 shopping district. It is adjacent to a corner business at Willow and Clark Avenue, consisting of a vacant storefront and barber shop. It is separated by a public alley that further provides access to the rear of the building fronting Market Street. On the south side of the building is a small private parking lot associated with the former bank building fronting Market Street. Across the street, there's a vacant lot that once contained commercial structures. They were recently demolished by the city, I think 2 years ago. They recently had an additional demolish. The armory was additionally demolished within the last month or so as well, just beyond that property. All property in the vicinity of the site is zoned B1 shopping district, which is reflected on Figure 4, the zoning map excerpt. The land use activities that are permitted in the downtown B1 zoning district are found in sections 230-62, 230-63, 230-64, and 230-65 of the city zoning code. The B1 zoning references are further shown in Exhibit 3. In the B1 zoning district under 230-62, principal permitted uses, item N, it makes reference to allowing dwellings only on the second or third floors. Furthermore, in 230-65 use regulations, prohibited uses, it states F. Prohibited uses include only uses first allowed in a lower zoning district and residential apartments or housing units at first floor ground level. We did point out that staff was aware that the Board of Zoning Appeals have previously granted variances in a somewhat similar case to allow residential use on the first floor of a one-story brick building at 21 Clark Avenue. That's across from City Hall here. It's at the corner of Clark and Vine. That application also housed a dog grooming business, as well as the owners lived in the apartment as part of that overall building. The dog business, I think, has ceased operation, but the owners continue to live in that residence. And that was application 16-4, filed or approved on April 12th, 2016. We also point out the Board of Zoning Appeals granted relief to the Firehouse Apartments on 5th Street to allow an ADA accessible apartment on the first floor, along with multiple apartments on the second floor as a conditional use application. That was approved in February of 2023. So in your package, we've also included guidelines and standards that the board should be considered in granting variances. That's reflected in Exhibit 4. I won't review those in detail. I think you've all seen those before or haven't had a chance to look at those. But final comments from staff. From a staff perspective, we don't believe there are any exceptional or extraordinary circumstances or conditions associated with this property. The building's original design was for business. There is precedent set for granting of a variance in at least 2 applications for properties also located within the B1 zoning district. The authorization of such variances will not be a substantial detriment to adjacent property owners, properties in staff's opinion. We do point out that the owner has not applied for appropriate building permits in order to comply with basic safety and building code requirements. For example, there may be a fire suppression sprinkler system requirement since you're going from business to residential use. There's other building code requirements that potentially come into play, such as size of a window for escape purposes in a bedroom, or a number of access entry points, plumbing, electric, all could present a hazard that's not done correctly. So building permits were not applied for, and that could be a safety concern. So staff does recommend, if you do grant relief, we would ask that the board put a condition on the owner that they be required to submit full plans prepared by a registered design professional that certifies that that use can meet building code requirements. So that concludes my staff report. Be happy to answer any questions,
I have a couple.
or if you'd like to turn it over to the owners and make a presentation and hear.
How do you want? Okay, so I'm gonna go ahead and ask my question to you, to the staff. Is that okay?
Mhm.
Okay, so, I know we did a lot of demolition, like you already said. In the future, are there plans for more commercial buildings to be built up where like Willow Street was tore down?
Nothing's on file yet. We certainly hope that's going to be the occasion. We do see the potential for more residential in the downtown shopping district. And we've discovered in doing some research, there probably are 5 or 6 properties in the B1 zoning district that we believe may be not appropriately zoned B1, such as 4 or 5 houses on Second Street going, if you're aware of where the fire was at 305 Second Street. That property, as well as 3 or 4 houses in the catty corner block, we don't believe are zoned correctly to residential. So we think there are mistakes in the zoning. As you're aware, we do have townhouses potentially coming close to Riverside Drive and Clark Avenue. That is not zone B1, but with the vacant properties that we have downtown, moving forward with the comprehensive plan update, may be appropriate time to look at the overall zoning patterns in that general 10-block area and see if it's consistent with the vision of what the city wants to proceed with. So I don't see anything right now on the horizon, but it's always opportunities with vacant parcels that we own.
But do you think, to the best of your knowledge, it would be more commercial being built where Willow Street was? Or
That's the logical, I think, use for that border, that particular block, yeah.
This may not be a question you can answer, but do you know when it became a residential property?
What's what?
When they turned it into a residential property?
When this one turned into?
Yes,
It
sir.
was about October, we believe, when we first discovered it, 2024.
Okay, I think the rest of my questions are for the, thank you.
Anything else?
On the previous exceptions to the B1, you say there's no exceptional, extraordinary circumstances or conditions or hardships associated with this. Were there any conditions, any extraordinary circumstances or conditions on previous allowances?
In reviewing that file, it's been a while since I looked at the one for the dog grooming business. I don't recall any special conditions put on that. I don't recall any special conditions on the firehouse apartment, ADA apartment. I'd have to double check, but I don't recall any special conditions.
Other than it was the only way to get an ADA apartment in that building.
That was the only way they could do that, grant relief from the Board of Zoning Appeals, which also you acted on, meaning the Board of Zoning Appeals acted on the conditional use to allow multifamily uses in the B1 zoning district on the upper floors. That was part of the action as well.
Right. I'm just saying, just carrying on from what you're saying, that to me that there were 2 that were approved. I was not on the board when the dog grooming place was approved, but that was an owner-run business, and the owner was going to live in the properties. To me, that was a little different case what we're talking about this evening. The other one, which I voted against passing it, but the board did pass, that was limited to the ADA use on the first floor of the firehouse.
Mm.
So I mean, to me, they were going to be one zone, but they were different stories, entirely different, in my opinion. Obviously not the board's, because I voted against it and they voted for it, so.
Anything else?
Well, to piggyback off of that, I was gonna ask, in the exceptions before, was there an agreement that the storefront had to be an open business for the owners to live?
For the dog grooming business?
For the dog groomers,
I
yeah.
don't think it was a requirement.
Okay,
The owners had to continue to live there regardless.
so the business didn't have to be open, it didn't have to be a.
I don't think that was a
Okay.
condition.
Okay,
I'd have to look at that file again, but I don't recall that being a condition of approval.
okay,
But again, it was owner occupied, which To me, it's the whole, all the difference.
Yeah, it is. Different situation.
Anything else? I'll turn it over to the chair.
No, we can hear from the. Thank you. Okay, if you are here either as the petitioner, or if you are here in support of the petitioner, or if you're here, and you oppose the petition and you intend to testify, I need to place you under oath. I can do that as a group. So if you intend to testify, I'd like you to stand and please raise your right hand. If you're gonna testify. Do you swear or affirm under penalties of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Thank you. Okay, so we will hear first from the petitioner in this matter, and then after the petitioner makes their case, any proponents who want to speak in favor of the variance have an opportunity to do so. And after that, any opponents have an opportunity to speak. I would ask that when you are speaking, that you state your name clearly and also indicate your address.
My name is Khurram Riaz, and my address is 429 West Market Street, Snow Hill, MD 21863. If anybody have questions, I'm available.
Do you have anything you want to add that's not already been presented to us?
No, whatever I have, I write down the application. We have no concern.
Is it okay for me to ask the questions now or after? The only thing I'll do before we start questions for you is, you had submitted, I assume you submitted to, the planning director some kind of documentation. Is that true? Did you submit anything?
I got a language problem too.
The letter.
Yeah, I send it, yes.
Is that already part of your staff report? Okay. I
Yeah.
just wanted to make sure that
Yes.
everything that you had
Yes,
submitted was
yes,
part
yes,
of that.
I did, yes, I did.
Oh, so I can go ahead. Okay. Prior to having decided to rent out your property, did you get a lead inspection done per state regulations?
No, nothing. That's my first time. I don't know anything.
Okay.
Yeah.
When did you turn it into a residential property?
It's October, November, something like that. I'm not exact date sure in my mind right now.
Okay. How much are you charging for rent?
First, when the happen is nobody in there, but before they have the business, but the business lady is gone after 3-4 months. Nobody in the building, and one day I go over there and one lady is already in the front door and sleep in the car, and I knock the door. Young lady, you okay? She say yes, she okay, and she say she have no house. That's why she sleep in the car. I say there's nobody in this building. You can stay over there because rain is coming, and you can stay in there. After 2 days, I go back and she's still over there, and I say everything is okay. You need anything? She said no, and I said you like over there? She said yes, and then I find out she's a teacher in the school. And I said, you can stay over there. Don't give me nothing, anything. Whenever you can find the house, you can move, and that's your key, and you can stay over there. But after 2 weeks, she called me and she said, no, I can give you the rent. And I said, if you afford it, that's fine. But if you don't afford it, you can stay over there. And she'd start giving me the rent for $1,000. And I pay. She said, you can pay electric. I said, yes, because electric is separate. I say, okay, I can pay electric and you can give me the rent if you want. And then she start giving me after 1.5 months, she get probably 2 months maybe, she can start giving me the rent for $1,000 a month.
Okay. And just so I understand, you can't gain access from the Willow Street property to the Market Street property?
No,
Okay.
it's separate.
That's all I have.
Thank you.
I have a question. No one else says. Is the property occupied or vacant at this time?
She's in there already.
She's still living there?
Yes,
So when the city notified you to cease the operation, you do not comply with the city's request, is that correct?
whatever city need, I can help, whatever she need, I can go with and whatever she need, right? Whatever, what he say?
I think the discussion was, you know, we informed you that you did not have the permits and it was not correctly zoned for that. You had the right to appeal. I think shortly after that, you filed your appeal.
Yes,
And delayed the
Yeah.
process in the public hearing, but we did finally get it scheduled.
yes,
Because, I mean, in the notes, the staff notes, it said you told them to cease the operation, but they did not. Is there a second, I know there are two entrances on the front. Is there a separate exit anywhere to the property?
no,
Just the two front doors?
just two front
side by
doors.
side? The storage area, that, is your intent to use that for a bedroom at some point in time, or is that?
No, she got a one bedroom and one she got all trash. I
Right,
go
I'm talking
to,
about in the future though, is that?
no, she's just by herself, sometimes his
Well,
son
yeah,
can.
not talking about that tenant, but future tenants that you have, that,
Whatever the town say, I can obey the law. I have no plan for future, but whatever is the town say, I can do, whatever, the course, I do.
When you, I guess your obvious plan is to generate cash flow out of that. You probably could generate more income as a residence than you could as a business, is that?
Yes,
Okay.
because we try 2, 3 different business, but business is not because there's a backsides and nobody going there. It's 2, 3 different business table there, one business 6 month, one I think 8 month or something like that, but they just leave, nobody, business is, that's a backside.
I'm
nobody-
saying.
Yeah.
My obvious question is that if this were approved this evening, would you be back to us in another few weeks to convert the Market Street side and do the same thing with that?
No,
Why not? I mean, what's the difference between Willow Street and Market Street?
Market Street is whole lot of people, in running on backside is nobody ever there. Since I got in 221, I buy this building in 2021, right now 25, so 4 year experience. I see nobody, every time I go, no, I will not see nobody in the backside.
But beginning in your notes, it said that your other place has been vacant for a long while, correct?
Yes.
Okay. Then, again, as you said in your notes, something's better than nothing, and your letter, I think you
Yes.
presented that if this were approved, do you think that would give you the ability to come back and ask for the same request for the Market Street side?
Market Street side, I put the signboard, lot of people calling, and then they say, okay, we can decide. And
No, I'm talking about as a residential use is what I'm saying.
right now, I have no plan for the residency on the front side.
At this point in time.
Yes.
Okay, that's all the questions I have right now.
Thank you.
A clarification, so the staff informed the owners that they had to cease operations for residential use, but had the right to appeal and file for variance. Were they under the obligation to still cease that during the period of the appeal?
Well, the filing of the appeal would stay the order. There were a significant safety hazard. You probably could have taken action right away to order it closed, but on my inspection of it at that time, I didn't feel there was a significant safety hazard that warranted immediate eviction. I did view it as somewhat of a hardship situation.
Everybody got any questions? At this time, if you wouldn't mind, having a seat so everybody else can.
Thank you so much.
Thank
I
you.
really appreciate it for everybody.
Thank you. Who would like to go first?
Let's, if there are if anyone here wants to speak in favor of the granting of the variance, we'll take that testimony first. If not, then,
Okay, if anybody's in favor of this, please come forward to give your testimony. Please let the record show that nobody stood up. Can I hear the first, nay from the audience, please?
Mark Shear, 107 Winter Quarters Drive, Pocomoke City, Maryland.
Hi.
Hi. I own the store right next door, Shear's Bridal Shop, and our alley goes out the back way. But the main thing is, I want to thank the city, you guys, Dan. I mean, Willow Street looks, when I was growing up, it was thriving. I mean, businesses, the Armory was open and busy. Down where Chip owns now, that was great. And, now it looks amazing and the possibilities are endless. We can really do some great things. And, so many young people, Chip, Jasmine are here and are buying up buildings. And it's B1. You can't say, well, this on Willow Street. I know that there was other things and there was definitely circumstances that led to your decision, but B1 is B1. So if you make an exception without unusual circumstances, maybe the owner wants to live there and can't live upstairs. That might be something, but there's no, you open the door to this, no developer is going to come in. That beautiful property that is just available, in my opinion. And that's my thing for B1, but as the adjoining property and the people that are there now, now the store is empty, but people live upstairs. Is that okay for them to live upstairs at this point? And I don't know how many people are allowed, but it's a lot of people that live upstairs there. And I've had issues in the back alley when as far as trash and everything else. And at the time the store was open and I got up with, whoever was there that had some authority, like, look, I actually gave them a trash can because they had trash in Walmart bags in a Walmart cart. And I put the trash in the trash can that I gave them. And I put the cart in the back of my car and took it back to Walmart. And then I had an issue when the store was closed. Mattresses were in the alley and tried to get up with somebody. I was going to move them out for bulk trash day, but they were drenched. I couldn't move them. So I had no choice but to call Dan and Mike, and they took care of it. And like I said, that has nothing to do with B1, but I'm talking about the landlord I'm dealing with that's next door to me. There's nobody to get up with. I don't even know if it's legal for people to live upstairs. I thought that the owner of the business could live in the second story apartment, just like, Simply Sublime, something like that. But anyway.
Thank you.
Thank you.
Can he come back up to, or do you want me to wait until the owner wants to come back? So should he
So
wait until?
We want to get through the public comments and then the owner will have a chance to rebut at the end.
Would the next person please come forward? Hi.
Better?
Mark Thompson. Mark Thompson, 147 Market Street. I own Simply Sublime, live above. I also manage the Marva Theater. I think we'd set a bad precedent by having somebody living on the first floor. We have Willow Street finally starting to come up. We have one business out there running. Chip's looking to open up a second, and the beautiful property across that's looking to build up. If we start having residents go there, it just starts a bad precedence. That's all I'm saying.
Thank you.
Thanks.
Jim Choquette, 809 White Oaks Lane, but also owner of two businesses on Willow Street. So I guess the first point, I was kind of surprised that there was two precedent. I wasn't aware of the dog grooming shop, and I had reviewed the code prior to coming here tonight, and I don't see any possible exception that even allows this. There's multifamily townhome that are allowed as exceptions in the B1 that would allow first floor. And I missed the meeting about the firehouse. In practice, I would have been opposed as you were. But I could see where that might have been allowed based on the multifamily rule for B1 and having green space. This building has zero green space, so it's not, doesn't seem like there's any allowance. But to pivot, take that hat off. As a business owner on Willow Street, I own two buildings, 2 of 4 storefronts that currently exist on Willow Street. One is about to open next month, pending, need to meet with Dan and get a license. And it's a destination business. It doesn't rely on street traffic, as a salon would have been a destination business as it existed. Was disappointed to see the gift shop not make it, but there is a little foot traffic. That's a valid argument, but you have to adapt. The trading post is back there now. He's doing well as far as I can tell. And I'm hoping to open a third business on the first floor. I understand the rent pressure. When I purchased, I have probably the closest similar building to this building in particular. 113 Willow was a single story, small, 400 and some square foot building. And when I bought it, it was only making like $400 in rent a month. It's not much. You could charge more for somebody to live there. And as a business decision, sure, that's great. But as a decision for the town, it's not a positive thing. And as far as, I know you have several criteria to make your decision based off of. And most appropriate use of land and structures. This is a commercial structure. There's no doubt about it. This was never meant to be a residential structure. Conservation of property values. This is not positive for my property value. There's constantly trash out front because it's residential. We take our trash out at least twice a week. Commercial businesses don't do that. Contribution or addition it would make towards deterioration of the neighborhood. I think if you open this store, I appreciate your line of questioning with Market Street. There's no reason we wouldn't go down that path with any business, especially landlord-owned buildings. Why wouldn't they go for the path of most profit of trying to get more residential downtown? And then at that point, you just write off the downtown. It's just a big apartment. So I am 100% opposed for all these reasons. I don't think it's a positive addition. Don't think it's the right thing to do there. The plight of this particular person, that sounds terrible. There are resources. I didn't hear any talk about, hey, we have a homeless shelter in town. But that's not the problem with the B1 district to solve. Like, we can't just open our doors and turn the B1 district into a homeless shelter. That's not the right thing to do. So yeah, all the above, I'm opposed. So thank you for your time.
Thank you. Now the next person, please. Are there any, thank you.
I'm not gonna be as spoken as Chip either, so. Justin Derry, 12 Front Street. I also run the business Cypress Roots Brewing of 148 Market Street, so he's only 3 buildings down from me. I'm also on the Planning and Zoning Commission, so this kind of hits home to me. I do think there is reasoning for having code in our B1 district, and I think we should abide by those rules. It has to be something oddly unusual for me to believe that the appeal situation become in play. Also, at his point, if we approve this back behind this building, what's to stop him from coming in and appealing for the front side on Market Street? So I really do think that the downtown district should be for businesses. I'm not opposed to people living on the second story with the business down open below. But yeah, it's like going to the Walmart area and opening up a residential and Taco Bell, you just can't. I mean, it's not built for it. So it's just my opinion. So I'm 100% against it as well. Thank you.
Thank you. Would anybody else like to testify? Go on. Owner, if you would like to come back up to review.
Thanks for giving me chance. I'm answer the Mr. Mike, my neighbor. He's asked me trash and this and that. But if anybody stay upstairs, of course, he need to be put the trash on the backside, but he got always complaints soon, I got 2021, that's not first time. Every month he call town, the town call me or he call me or call somebody else, let him know my tender always got problems. I don't know what's wrong with this man. The first week when I buy the building, I go over there and he's the next to the my building. Bottom side is the rain coming, anybody can go anytime when the rain coming, the water came from his building to my building. Still, I asked him, I wanna see where the water came, so they're not damaging my building. He said, no, leave. I said, okay. He not compromise with me. That's the reason he always behind. Still, I'm request him to give me the option. Anybody can go and check. Mr. Don can go and check inside. Water when the rain came, his water pipe is in my building, not water supposed to be came outside. They come and basement, my basement is full of water when the rain came. And I got motor on it and they can put the water outside. All water came his building to in my building and damaged my building already. Anybody can see anytime and check when the rain is coming. And still complains without, and I never complained in my life since 2021. He always complained and he not give me permission to, I can find out. He said, door is closed, I cannot open the door. My building is messed up and you not give me permission to go inside and check what's where the water came and even not fix the water. He's still coming for 4 years. Every time rain came, whole lot of my basement is full of water. Anybody can go and check. I cannot able to fix it because I have not enough money to fix this one. And he not give me permission to fix. So inside I can check where the water came so I can stop leaking. He not give me permission to come inside. Because water came from his building. Anybody can go any day and check when the rain is came. That's it. Thanks for giving me time. Appreciate it.
Thank you. Not at this time. I'm sorry. Yeah.
Okay, so if you, as long as you all don't have any more questions for anybody, we will close the public portion of the hearing. So you all, and so you do that, and then the discussion would just be among you all. That's not to say the public has to leave. It's just there be no more testimony.
Does anybody have any questions for anybody?
I got one last thing.
Okay.
See, I heard that some of my brothers say, well, this is a B1 zone. We try to open the business for 3-4 different business. No business is run. That's why we try to decide make a for the residents. We try first. We obey the law. We try first, and then we have option to agenda for the zoning appeal. That's why we go in this part. We try 3 different business, and everybody know Miss Dawn when the cutting. The before lady will be kitchen, you'll be able to manage cutting the ribbon. We try 3 different times, but the business is not open. So that's why we think something is better than nothing, at least just empty in the building and looking bad. So at least somebody, so be empty building, somebody can stay, so somebody can satisfy. We try 3-4 times to different business and different peoples, not me, different peoples that open up cutting shop or some other lady illusion shop. Before she worked in this place too. So everybody know in the town, but that's our, we try first to open the business with 3 different business in past 4 years, no business be, able, that's why we have no choice. That's why we say something is better than nothing. So at least people come this and that building not be messed up. If they empty, nobody came, no business, they be messed up, nothing, no door open, no window open, building messed up.
I
That's
have a quick question.
Yes.
I believe I saw your advertisement online for your Market Street building.
Yes.
And your rent is 1,500. Have
Yes.
you considered lowering your
Sure.
rent?
Sure.
Okay.
Whatever, it doesn't matter. Anybody if they give 1,800, it's not, at least the shop is open and the town looking good, Market Street looking good. I'm happy. That's it. Something is better than this. Rent is not no big deal. I don't know how to do it. That's my friend do it, but I can change it.
Yeah, I
Rent down.
think, I mean, and I know this isn't relevant to what we're dealing with right this second, but I think if you lowered your rent, you may find that you would.
Sure, I can do tomorrow and ask my friend. He know how to use the computer. I have no knowledge, but he can change the price to between 15 to 1,200 or 1,000, but maybe 1,000. That's be fine.
I think that would benefit.
Yeah, I do. No problem. Next 2-3 days we change the price for market, please. Thank you so much. I really appreciate for everyone.
Really quick, just to make it clear to everybody, you feel that the residential building that you have is the most success that you've had in a while on Willow Street or Market Street, which is why you're saying that something is better than nothing.
That's for the backside of the.
Yeah, for the backside,
Yes.
that's the most success you've had as
Yes.
a business owner, and how long, would you say?
No, I'm we try to, I'm not a business owner, that's my, I'm on the owner of the property.
Okay, okay, okay,
And we try to open 2, 3 different people came and they apply for the business. We try to open and they open 6 months, 8 months, they're not one.
Mhm.
So then the 2, 3, 4 month building is nothing, nobody in there did. So that's why we try to think somebody, the lady came and the happen, I say, okay, we can try, let's see what happens. Because nothing, is somebody staying there, that's be better. If nobody stay, the building messed up, is not looking good, if nobody staying there and our building messed up.
Mhm.
So that's my point, but whatever you decide, that's better, that's fine. Whatever,
Okay,
yeah.
okay.
Yeah, we try,
you're-
everybody say the B1 is supposed to be business, we have option. You can, if the business is not running, you can option B, use the option B.
And-
That's the point.
And your plan as of now for Market Street is for someone to rent it and run their business?
In the
there?
future, yes,
That's.
on the
okay.
first part, that's on the backside, one Willow Street on the backside.
Yeah, yeah, I understand that, but for Market Street, I mean.
Their
I think-
business, yes.
I think he asked before, like, even if you were granted this today, your plan for Market Street is to have someone rent it out and run
Yes,
their
business, yes,
Okay.
yes. I can make the rent down, so maybe somebody can trust this and
Okay.
open the shop, yes. Yeah, business on that.
Yep, that's
Thank you
all,
so
that's
much.
it.
I really appreciate it. Yes.
Why did you not apply for building?
Because that's my first time. I have no idea. I live in Snow Hill, but right now, as soon as I know I can apply, I have no idea before. Yeah, that's
I'm
the,
gonna tell you right now, you have to go back in here, if this were to be granted.
no, I
you
can
have to go
apply.
Back in there and spend a lot of additional money, bring that thing up to what it needs to be.
Yeah, because,
Are you aware of that? I mean, the kind of money you're gonna have to invest over top of what you already have to get that to come up to compliance.
no,
You're gonna have to get a registered professional to probably redo that floor plan. Your windows are probably gonna have to go, they're not egress windows. Possibility again of like,
Yeah, we're building is
uh,
very.
you're gonna have a survey done.
yeah, that's fine. We can try whatever.
I don't agree with not knowing that you needed a building. That's pretty basic.
Yeah, that's the first time I buy this property in my life, the first, and I'm living Pocomoke and sorry, Snow Hill, so soon as I know everything, I can obey the law, whatever I know. If I don't know anything, I have no, but before, that's first time, so I don't know, we need a building permit. Even I don't know, this is the hall over there, first time when I have no idea, but slowly, I need everything soon. I go in there and can know how deep is the life. That's just started, so that's the reason.
Anybody else have any questions?
I was gonna just ask if you had anything that you wanted to highlight as a hardship or something extraordinary about it to lead us towards approving it? Anything that you wanted to highlight?
No, nothing. Thank you. Appreciate it. Thanks for everybody. I really appreciate it.
Thank you.
Yeah, I have one other thing that I neglected to bring up earlier when I was talking about the 2 decisions been made before by the board. The dog grooming place, again, which was owner occupied, residential and commercial, and that and the firehouse, both, there was one very significant difference other than the ADA and the owner occupied, is that both of those had ample off-street parking. None of these have any, and I'm not sure, it's kind of vague to me if the city requires it, doesn't require it. Both of the other variances were approved, and they had ample off-street parking. That, to me, is a big difference that this property does not have.
So do I now close the,
If there's no more testimony from the applicant, the next step would be to close the public portion of the hearing. And by that, I mean, there's no more testimony, the evidence has been received. And then the board can discuss and go through, the law and render a decision. So if the board is ready to do that, you would do that now.
okay, all right, Sir, are you done testifying?
I don't know what's the testifying.
Are you done, explaining and?
Yes, I'm done. Thank you.
Okay, thank you.
I appreciate it.
And this concludes the public hearing. Did we turn on?
No, because we're gonna, so the public portion of the meeting is over. That doesn't mean you can't stay and be a part of it, you know, and observe, but that just means that the board's not going to receive any more evidence or hear any testimony. And so now it's the board's opportunity to review the law, review the evidence, and then render a decision. And if you have any questions, you know, for me, you can.
Okay, thank you.
Do you have any discussion?
I was, I really don't think that we should approve it.
To help guide, you know, you to get to your ultimate decision, I would encourage you to look at section 230-107. I believe that was provided by Mr. Bradley in the material. That discusses variances and it discusses the various findings that would have to be made in order to approve of it. So it's a good roadmap on the things we could be discussing now.
Testimony, the reminder was very important to substantiate the decision and give reasons for your decision. It's not sufficient just to say, recommend it on the document.
Right.
Take the reason.
So the reason why I think it's a no for me is because it doesn't meet any of the permittable rules for the city. Not to mention, hopefully Willow Street will be built back up as a business area, and that I feel like would hinder that.
I'm kind of looking at, variances and then number one, new variance ship and the provision or requirement shall be authorized at 4 times non-reasonable doubt that all the following facts and conditions exist, and they talk about extraordinary, circumstances or exceptional conditions. I'm not aware of anything that's extraordinary, or exceptional about the building.
B, it says such variance is necessary for the preservation and enjoyment of substantial property rights possessed by other properties in the state zoning. That's certainly not applicable.
I don't think it meets any of them, plus by mission from the applicant said that it's not created a hardship, so there's any question about it.
Does anybody have anything else they'd like to add?
Property. Not so that general or recurrent natures make reasonably practical the formation of general regulations. So it does seem like it falls into that could just be asked for, again, to turn more forefronts into residences.
I think if this were approved tonight, it would be very, very difficult to deny anyone else in the future. So this is a very important decision, in my mind.
I don't feel this property meets those other two, like the firehouse or the golf.
Well, so they're in my mind, they were different
Yeah.
animals altogether.
That's how I feel about it as well.
You're waiting for a motion, is that?
Well, I didn't know, you looked like you were covering. Then somebody should make a motion. You can call for somebody to make a motion, or somebody's welcome to just make a motion, and then you go from there. Are we ready to make a motion? For anybody?
I'll make a motion to deny the application because it does not meet any of the criteria that's listed in our report.
We'd ask if there's any further discussion.
Is there any other discussion? No. Motion so carried?
Well,
Oh.
you guys have to vote on the motion itself.
Okay. So approved motion?
You would want to ask, all in favor of the motion to deny the application for a variance.
All in favor to deny the application for variance? Motion so approved.
Just so the record is clear, it's a unanimous vote. Is that accurate?
Yes.
Okay, so.
Ready to move on?
Yes.
You want to tackle the bylaws or vote for officers or?
Really, it's crazy that it's already been a year since the last time we voted somebody in as a vice and chairperson.
I think activity is going to pick up this year.
I hope so. So, do I say move into the next order of business? Moving on to the next order of business, electing chair and vice chair.
Well, does anybody want it?
I don't mind saying this. I think I'm starting, like, more of these I have, I think I can be able to word things better. But I don't know if somebody else wants to take the reins, please, by all means.
Nominate Kelly to keep her position.
I'll second that.
Looks like you will.
Okay, so,
Unless somebody else wants to.
Unless you want to vote against it.
Yeah, exactly.
everybody in favor of keeping Kelly Miller as the chair? Please let the record show that everybody agreed.
What about vice chair?
Okay, so now we need to vote for the vice chair. Who would like to take that? Would you like to keep it?
Is it me?
Yeah.
Oh, gosh. I thought this was me.
No, no.
I'm- Keep it.
We need a motion to,
Everybody in favor for
So, yes.
keeping David Strauss as the vice chair? Please let the record show everybody was agreed.
Like to nominate Chip.
Yeah, I feel like you're on the wrong side.
I was surprised to see you back there, honestly.
Uh, Now moving on to, now we're gonna move on to the approval of the minutes from the last meeting we had on May, oh no, that's the date.
May 8th, yeah,
What is it?
May 8th, 2024.
Oh, that was, oh my God, I'm sorry. We need to approve the minutes for May 8th of 2024.
Rather than it's the way I remember it, so I'm making a motion to approve the minutes as presented.
All in favor of approving the minutes? I guess it was just me and you there, right?
Oh,
Oh, and David.
David was there.
who they-
Yeah. Oh, this was the small residence over on Seventh Street?
Yes, on the corner of
Yeah, that's right.
7th and Cedar, yeah.
Yeah.
All in favor of passing that?
All right.
Please let the record show that everybody approved that. Now moving to review and discuss draft and bylaws. Is there anything against that, am I doing something wrong? Oh, okay, sorry, I thought you were shaking your head no. Is there any way that we could get the minutes sooner than the following meeting? Cause as it were, it's already been 9 months since the last time we met, so sometimes it's hard to recall. Is that possible?
Yeah, they should really be sent out within 30 days or sooner, so it stays fresh, and may have to call another board meeting to act officially on the minutes, but yeah, they should be sent out quicker.
Is there a way that we could add that to this, if it's not already in here?
To what?
To the,
Are you on the?
yeah, the Maryland.
So you're looking at the code, so let's, if I may, say something about it. So, it is tricky for minutes when the, frequency of hearings is so. Regardless of whether or not it's in the rules, we're supposed to be compliant with the Open Meetings Act. And so in that case, the minutes should really be done, and looked at as soon as practicable. But the problem with a situation like this is it's not always prudent to call a meeting for the sole purpose of minutes. So I think that's kind of what we're dealing with. I don't know that we would need to add something in the rules of procedure that says when minutes need to be approved, because I think we might get into situations where we're violating our rules.
Right.
But I think as long as we're trying to follow the Open Meetings Act as best as we can, I think my opinion is that that's sufficient.
Okay.
If the minutes can be done in draft form that, so they can be looked at, that would be fine. It's just the official act of approving the minutes, just can't happen.
And there is, would it be a violation if we did it like via email?
It would be a violation of approving them, as an official act
Okay.
by email. There's not a problem if the minutes are in draft form and they're sent out, just so it stays fresh in your mind.
Right.
But then if there are any changes that need to be made, that has to happen during the open meeting.
If we were to have a meeting to review the minutes and approve them, would that meeting have minutes that then needed to be approved?
Yes,
Yeah.
yes.
So then we would get, we'd be stuck in a.
And everything's cycle there.
We'd get stuck in a loop.
The way I think it does refer to that is on page 8, Rule 10, item C. And it says minutes shall be prepared as soon as practicable. But beyond that, it doesn't provide more guidance, but. Yeah, it's difficult when we don't have regularly scheduled meetings, so we do need to get those out sooner, get them in your hands to look at. Could become more of a problem if you don't have the 3 or 4 board members there to vote on those minutes in a subsequent meeting, so that is an issue sometimes.
Well, I have a question. I've often thought about this, but just like tonight when we approved the minutes from the previous meeting, there were 3 of us here, so the 2 new members technically could not vote on that. Is that correct? I mean, I know it's an odd.
It's one of those situations where I think they have to vote on it because you need the members of the board for the vote. But I agree with you that it's kind of a weird situation. And so I think what I would say to that is if the members who are sitting on the board who were present, if they took issue with it, and they were to express that issue, if there was another board member who wasn't there, they could base their reasoning on approval or not approval based on what they said. But yeah, I think
It's an odd situation.
it's odd, and I think that's just what happens when you don't meet that frequently.
Well, at the same time, there's 3 of us sitting present, and would that not represent a quorum?
Yes, it would, but I'm just saying that's not always the case, so that we're affirming to a meeting that they didn't attend, so it's like.
And maybe that's a reason to call a meeting when, even though there's nothing in front of the board except for the approval of minutes, just so we don't have to worry about that situation.
I thought we were getting into a loop like that.
Yeah, I understand.
Groundhog.
Yeah.
So, all in favor?
Well, I'm sure Mr. Brandon probably has a presentation on that for us, or no?
You've approved the minutes, correct?
Yes.
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 This also has been a work that's been in progress regarding the bylaws for several months now. I think we first presented a draft back in May as well. Beyond that, these are very detailed bylaws. In many cases, Board of Zoning Appeals don't have this level of detail in bylaws, but I think in my professional experience, the more the better. If it covers all the bases that you come across as a board, it's helpful, I think, to have this guidance in it. Ms. Witz did come up with some comments on page 7 and handed out some comments. One of the interesting dynamics of a board is when you don't have all 5 members present to hear the case and act on the case. You should have this copy right here. If you, everybody have that?
Is that the page 7?
This is page 7, reprinted.
Yes, I have it.
Everybody have that?
Yeah.
Yeah.
You have that, Marcus?
Yep, I have it.
You got it? I've got a couple extras if you don't.
I think you need to. This is been redone, so. So now that section.
I had a question about that.
I'll take it. Oh, thank you.
I think I may have been the only one here first gave it out.
So one of the dynamics I mentioned was that when you don't have a full board, some could view the fact that not all 5 members that are voting on an application, could it be viewed that you're shorting the opportunity of the applicant to have the 5 members of the citizens of the city appointed to hear these cases. So what happens then when you have 4 members? What happens when you have 3 members? The way it's written is a quorum is 3 members. So majority vote of the quorum is 2 out of 3 in the case of 3 people attending, be 3 out of the 4 if 4 members are in attendance, and 3 out of 5 would have to vote for when you have a full board present. So then the question is, okay, do you want to give the opportunity to the applicant an opportunity to delay the hearing when you don't have 5 members present? Many times you'll probably find the applicant saying, no, go ahead, I want to hear it. But there could be situations where he feels he would like to have the full board present. So the way this is written on page 7 is that you are giving them an opportunity to delay the hearing until the next time that you would have the 5 members present. So Ms. Witz came up with some language that kind of confusing in the way it's written as far as, what happens if you have 2 out of 3, 3 out of 4, 3 out of 5. So I added some language that's highlighted in yellow that may help clarify that. She brought up the question of what happens with the tie vote. And the way it's written, as suggested by Ms. Witz, is that a tie vote shall indicate that the request application has received no action by the board and the application shall be deemed withdrawn. The application may then be resubmitted and re-advertised as a new application, thus requiring no fees to be paid. And then part of the reason why that's written that way is that there is language, I think, in state law that says if a board acts on an application, they cannot refile for a year. So by treating it as a withdrawn application, they can come back and resubmit the next month or the following 2 or 3 months later. And then it goes on to read, a tie vote on an appeal shall constitute a failure to achieve the required majority and the previous decision. And I added or administrative order subject to the appeal shall stand approved. So for example, if we issue an order from our office, they appeal that order. If it's a tie vote, the department's order stands, basically. So that's what that is referring to. Is that all clear as mud?
Yes.
Yeah.
So
I had a question. Are you going to go through? I have a question about one specific paragraph.
I just was going to add that in addition, there's 3 appendixes. I don't believe I mailed out in the packet, but they are basically covering the state law, Maryland annotated code, which is shown as Appendix A, and a real reference to the Board of Zoning Appeals and the state law guidance on how to run, operate, handle board meetings is under subtitle 3 on page 8, starting with section 4-301. That's the real part of the state law that you may want to just review and be familiar with. Most of it's then carried into our bylaws. The other appendix is the actual language from our local zoning code on the board's authority, their procedures, powers and duties, and their guidelines for decisions which you took into consideration tonight. The final appendix is Appendix C, Rules of Evidence. This is something I've really not come across before, but I thought it might be something that we should consider and provide guidelines as far as what can be presented as evidence and how to handle issues as far as calling witnesses, offering evidence, rebuttal of evidence, cross-examination. So that gives some more guidelines on the procedures for public hearings. Again, most of our public hearings and cases are not complex, but there could be complex hearings, which we would rely on Ms. Wetz for a lot of guidance in terms of following these rules of evidence and how to handle the meeting. So it's not necessary, absolutely necessary to have that, but it can't hurt. So that's all I had to say. If you have any questions, I don't intend to go through it in detail.
I've read it through a couple of times. The only question I had was, you could just clarify Rule 17, page 12. Number 17, page 12.
what the question is,
Well,
whether
I
the,
don't quite, it's request for the holder of the SE or CU for the owner of the, or the owner of the property, which, not sure whether it'd be different, but anyway. Board may approve a transfer, no public hearing shall be, unless the proposed transfer will subsequently change the nature and character. I mean, what, I didn't quite understand what they meant by changing the, you'd have to look at each individual case. I understand I understand about the, being able to transfer that. I didn't realize you could actually.
let's use the example of the dog groomer, and I should spell out what the acronyms stand for. But it's a special exception.
Conditional use.
Yeah, conditional use and special exception. I think in state law, they don't actually use the term conditional use, but in most zoning codes, they're interchangeable. It's either treated as a special exception or a conditional use. And there are some nuances about what is a special exception. But for the most part, they're interchangeable. But let's say the board acts on this dog grooming business where the owner lives in a building and the board says as a part of our variance, or let's say it's treated as a, it's not a good example. Let's go back to the firehouse example, where use of that building for multifamily apartments was a conditional use or special exception. So let's say that ownership is transferred. And the owner decides that he wants to maybe add a second dwelling unit on the first floor, possibly has an additional multifamily unit or a variant situation. So I don't know if that's a great example or not, but that would be a potential matter that could be brought back to the board. And you could say, we are authorizing an additional dwelling unit in the building, or you're authorizing maybe the ADA unit to be converted now to business, or the ADA unit to be expanded in size. Just thinking out loud of situations like that. So in other words, if you put conditions on it, which you have that authority as a board to do, the question is, can those conditions automatically transfer to a new property owner? For the most part, they do.
But who makes the determination if they come back, if it's substantial, who makes that determination?
It would probably be reviewed by staff initially, and
But so you would consent and present it to the board?
yeah.
Or recommend they look at it?
Yeah, and the question I think came up in our discussion, CD, about variances. If you grant a variance, let's say, as an example of a room addition that doesn't meet a side yard setback, the variance goes with the property. Let's say they never built that room addition. They come back 3 years later and they say, well, I want to build my room addition now. And I still don't meet the requirements, but you, the board, granted the variance, so that goes with the property. And that carries it in that manner. But special exception and conditions are a little bit different than variances, so.
I have a question next, this particular section two, now that we're talking about it. So if somebody, if ownership transfers and there's a special exception, that's already been approved. And so your thinking here is that, for it to be transferred, first they would approach you as the planning director, and then you would make a determination as to whether or not there's a substantial change in the nature of character and all those factors. The way I read this, though, is regardless of your determination, the transfer still has to be approved by the board. The question here is whether or not it's a public hearing, like a adversarial proceeding, or if it's just something that the board has to make a determination on. That's how I read it, and I want to make sure that I'm reading it right, and that's the.
Well, that's right. I read it, like I said, I've read the whole thing several times. Wasn't clear what the intent was.
Yeah, and if it's in staff's opinion, if it substantially changes the nature, character, or intensity of the use, it would be a public hearing then in front of the Board of Zoning Appeals, and notification to the adjacent property owners and posting a legal advertisement will all be required. And so you're giving the opportunity for everyone to comment on that application.
But even if your determination is there's no substantial change, it still has to be a presentation to the board.
That's how I read this.
That's what it says, yes, that's right, it has to be approved no matter what, even if
Yeah.
it's not a change. It's exactly the same thing, you're saying that the board still has to approve it though.
Yeah.
First sentence.
Okay, as long as that's the intention, that's how I read it,
Mhm.
that's all.
Exception for property registered.
How are they registered?
Yeah.
Only through the case documentation and the files. It's not like it's not,
No,
some zoning maps may have that reflected depending on the level of detail. I mean, it may be coded into the actual GIS format. It pops up on the map. Appeal number 125-25 may have been associated with that property. We don't have that level of detail, but it's possible it could be done that way, but then you would click on a link and the whole case file would come up if we were sophisticated enough, for example,
but we're not.
but we're not.
So,
So,
and I'm sure most cities aren't.
but
Most cities
yeah,
are.
it could be done in theory. You have to scan all the files, put a hyperlink to the PDF zoning code and each address, and I've seen it done.
Don't get too excited.
Yeah, other than that, I sort of read through it a few times, not that I understand all of it, but it seemed to make sense what I had read.
These came from model bylaws put out by the state for several communities. And I think I went through 3 or 4 and gathered what I thought were pertinent, good, applicable to our situation, and kind of condensed it.
Does anybody else have any questions about the bylaw?
One thing I think that did come up was possibly adding a preamble that the chairman would read at the beginning of a public hearing, and we can work on that if that's, you think is appropriate and helpful. So we could work on that and add that and present it back to the board if you're comfortable, if you want to vote on it tonight with that language to be added, subject to review and approval by our legal counsel and staff, and we can add that.
Does it, do I have to?
No, because I can.
Okay. Does anybody, is everybody in agreement with what, Mr. Dan Brandon just said?
We need a motion, is that correct?
Oh,
Or do-
everybody in favor of what?
We need a motion, is that to,
Yeah, I think it's
Go by
appropriate for the
consensus.
board to approve the
Yeah.
bylaws.
I make a motion to approve the draft as presented with the additional preamble that Dan had suggested. Seconded.
All in favor, say aye, and please let the record show that everybody agrees.
Motion carries.
But,
Yeah, no, somebody knows.
and now I'm gonna make a motion.
I think
Then I think that'd be appropriate. Make the motion to adjourn the meeting until next time. All in favor, please say aye. Please let the record show that everybody's in agreement, that we can go out.
First meeting. We'll be on here for one.
Thank you for your help.
Yeah, I just think, my 3-year term expired a year ago. I still not found anyone to replace me.
Appreciate that somebody who knows what's going on.
No, it's just, I did this. Yeah.
Thank you.
Oh, same. I'll let Rich know that you.
Holler at us below.
Yes, sir.
Yes, Dave.
Yep. Nice to meet you.
I know.
Yeah, 74.